Hi, I'm James Ballantyne and I'm the Managing Director of Ballantyne Law, and today I'm joined by Joyce Zhao of Herekind. Today we're talking about estate administration. One of the first things we get asked by our clients when we're talking to them about estate administration is how long the process actually takes. And the short answer is longer than people generally think.
Yes.
Even a conventional, straightforward estate administration will take months, not weeks. And when you factor in things like superannuation, grants of probate, and other property issues, will often take a year or more to completely finalise an estate. Much of the delays is not just the legal side of things. It can be in identifying assets, dealing with institutions, waiting for statutory timeframes to pass, and other processes which are beyond anyone's control. Understanding these timeframes early can help families plan and reduce frustration.
James, maybe it would be really great to work through for the families. What are the key stages in finalising an estate?
Each matter will fall on its own facts, but generally speaking, there's a few important stages that most will go through. And the first is really dealing with the immediate aftermath for family members. So dealing with things like funeral arrangements, organising death certificates, which will often be dealt with by funeral directors. And if there are no disputes about those issues, and sometimes unfortunately there are, and that's where we have to talk about urgent applications and otherwise. It's not until after the funeral and after a death certificate that's been issued that the real practical legal steps can begin to take. The first step is really identifying who the person responsible for administering the estate is, and that's if there's a will, it's going to be the executor or executors of that will. If no will is able to be found, then it will be the people entitled to the administration under the rules of intestacy. So once an executor has been identified, or the person with the authority has been identified, they can begin the process of identifying the assets, making sure assets are secure, making sure that there's nothing urgent that needs to be dealt with. Sometimes if there's something like a business that was owned by the deceased person and there's no signatories on bank accounts, it might be necessary to bring an urgent application to the court so that employees can be paid and critical issues can be dealt with. At this point, things like insurance for property should probably be dealt with. People should have a chat to their insurer to make sure properties are secure. And at this stage, often this is when we'll start to get phone calls from clients who need assistance. So sitting down with a lawyer and understanding what the processes and timeframes involved are. The next stage will be that information gathering exercise where once those properties have been identified and liabilities have been determined and bank accounts identified, we can start the process of determining whether grants will be required. Now a grant, whether it's a grant of probate or a grant of letters of administration, is the formal process that an estate is authorised to be administered either in accordance with the will or the similar document or an intestacy. Not all estates will require a grant of administration. It will depend on the nature of the assets and the jurisdiction that those assets are held in. Determining whether that's required is important because that will affect the timeframes and the processes involved. If a grant is required, the next stage is proceeding with that process, and that involves often some form of advertising, preparing applications and supporting affidavits and material, filing them with the court, and waiting for the process of the grant to be made. Once that grant happens, the estate can start to gather in those assets, close bank accounts, transmit property, deal with shares and bring them into the estate. During this process, often the executors will also start to locate and identify beneficiaries, the people entitled to receive the benefit of the estate. And then once the estate has been gathered in, bills can be paid, liabilities can be dealt with. And again, speaking generally, because there may be other issues, claims or litigation that's involved, the estate can start to head towards finalisation. Distributions can start to be made to beneficiaries, tax can be dealt with, tax returns can be filed, the estate can be finalised and closed. So often that's a very concise description of the process, but often that process can go over a period of times and the steps can cross over. There's often time frames, and they vary among different jurisdictions that offer protection for executors. So if the time frames are passed and then the executors make the distributions, they have protections at law. So they largely relate to things like family provision applications and similar applications. So often executors will wait until those timeframes passed until they make the final distributions from the estate.
So James, family often tell us that in estate administration, the lengthiest tasks are finding assets and liabilities and also dealing with institutions. Is that consistent with your experience?
Absolutely. Unfortunately, these days people have a variety of assets, particularly assets that are registered with institutions or government agencies or otherwise, whether that be bank accounts or shares or property or otherwise. And people often, even if they have prepared a will, don't have a central location of the information about those investments and otherwise. And families can be at a loss to identify who the deceased banked with, whether they held shares, who they held them with, what the account details are and are otherwise. The other delay is once they have identified those things is going through the process of dealing with the institutions in terms of finalising those assets. Each institution has its own internal policies and timeframes, and they have to be complied with. And people can spend a lot of time on the phone, by emails, navigating that process.
I find that consistent with our experience as well. People might often have a will in place, but it's actually tracking your assets and liabilities over the course of your life and keeping that up to date, which can be the challenge. And often when that is not in a centralised place, it's not easy to find for your family. On your death, it can take months for them to put together a full picture of what you actually had in your estate and what actually needs to be called in and dealt with.
That's right. Sometimes people don't even know about a specific type of asset or a specific bill or a specific liability until they receive a demand through the post to the deceased's address. That's also becoming more difficult these days as many institutions are moving to online-only accounts. And if people don't have access to emails of the deceased person, they're not going to receive a bank statement in the post. They're not going to identify those things. One of the best things you can do for your family is to have an up-to-date estate plan. Almost as important is to have a central register of the critical information that your family needs so they can administer the estate with a minimum of stress. Keeping that information up to date is important too. There's no point in having something that's 10 or 15 years out of date. There's a few different tools that people can use to do that, both digital and in physical media. We offer some things like letters of wishes, guidelines to guardians, executors, dossiers that allow people to start to keep this information up to date. Keeping it secure is obviously important because you may include some very critical personal financial information or passwords or otherwise, but also keeping it in a location that your chosen executors know where to find it is important too.
As an estate lawyer, I'd love to hear from you as to what your ideal file would look like. So if a family came to you, someone has just died, what would make it really easy for you to start your process?
The more organised the deceased is during their lifetime, the easier it will be for their family. Having information about where the will was located, information about the assets and liabilities and bank account information, SRNs, HINs, all of that data which assists clients in deal with an estate, reduce the amount of work that they may require from their legal advisors, makes those matters much easier to deal with. It's less stressful for the clients.